Good morning. I wish all my friends to mourn the Good Friday peacefully, and now I go with the judgment. Normally, what happens, taking advantage of relationship age, the people used to execute fake sale deed, fake gift deed, etc. Here, in the given case, also the uh, plaintiff filed a suit for declaration that late Hardai had gifted land to them during her lifetime, and gift deed dated 23/12/1985. Suit was filed in the year 1991. That is most important. Then actually what happened? Uh, the gift deed was not signed by the person. Uh, Therefore, the contradiction, lack of clarity, the lower court dismissed the claim. Pursuit for declaration and permanent injunction and possession. All that was rejected, but the second appeal, the High Court has allowed it. But the Supreme Court has said, this is most important, for the following proposition of law is valid for you to challenge if any such gift deed was executed and a claim was made. Number one, that though the gift deed was executed, why you have not mutated the records? Here in the given case, he seems to have filed an application for mutation of records on the basis of gift deed, but that was rejected. There was no appeal or writ, therefore our right was extinguished. It is a clear case that the document is fabricated. Therefore, the uh, Supreme Court has set aside the judgment of the second appeal and rejected the plaintiff claim on the strength of gift deed. This is AR 2022, Supreme Court 678, Kesav and others versus Gyan Chand and another. So most important thing, you can the one of the ground raised in this before the trial court and Supreme Court observation was that the person for whom the gift deed was executed did not sign the gift deed. That was one of the aspects they have considered. Then they have discussed about 122 and 123 of the Transfer of Property Act. How presumption of the registration of the document would substantiate. Then they have said, they say, the concurrent finding of facts arrived in the present case were based upon a holistic examination of the entire evidence relating to execution and validity of the gift deed. Therefore, unless and until, while considering the second appeal, if they are perverse or some gross illegalities, then only they can interfere with the finding. This was the judgment of the Supreme Court. So, for number one, by obtaining sale deed, gift deed, they ought to have mutated the records. If any adverse orders was passed, they ought to have preferred an appeal or writ or anything, other proceedings. And the gift deed would have been signed by the person to whom the gift was executed. Second appeal, while considering second appeal, this appellate court has no jurisdiction to interfere with the finding of the concurrent finding of the lower courts. I close this.